For Coogee.
Sing us a song.
Well, thank you, Madam Deputy Speaker. The Entertainment Industry Bill 2013 seeks to introduce fair regulation of talent representatives, including performer and venue representatives in the entertainment industry. The bill will repeal and replace the Entertainment Industry Act 1989 in response to the 2010 final report into the Act by the Better Regulation Office and New South Wales Industrial Relations, which made 25 recommendations. These recommendations have already, some of these recommendations have already been incorporated into regulations. New South Wales represents half of Australia's entertainment industry and is responsible for millions of dollars of investment and revenue generated in our economy. Therefore, we have the responsibility to ensure that those who work in this industry are adequately provided for and protected by the law when it comes to their work rights, specifically through their dealings with their representatives. The bill distinguishes between performer representatives and venue representatives. A performer representative seeks to find work opportunities for the performer, negotiates terms and conditions for a job and organises the performer's payment, similar to the duties undertaken by an agent in the current legislation. A venue representative acts on behalf of an entertainment industry hirer for financial benefit to arrange a performance at their client's venue, such as a pub. The bill will provide greater protections for performers following the removal of licensing requirements for industry agents and managers. Inevitably, in almost any industry, some don't follow the rules. This can be intentional or unintentional, but nevertheless, the New South Wales Government is seeking to take the initiative on this issue and provide appropriate protections in an industry in which many young and perhaps vulnerable people are working or seeking to work. Inexperienced performers may be faced with negotiating work arrangements without any prior experience or knowledge of their own rights and responsibilities. Therefore, the bill outlines a new set of comprehensive protections that will increase transparency for performers in dealing with their agents, addressing situations where there could be a knowledge imbalance. The bill does not seek to and will not advantage representatives who do follow the rules. It will benefit both performers and their representatives through clearer and effective contemporary regulation. For example, the bill introduces a cap on fees to be charged by representatives under the entertainment industry agreements. Representatives can only charge fees above the cap if they are assisting the performer in career management services, in addition to their role in finding the performer work. In keeping with the strict new requirements, any such career management services will need to be described in a signed, written managerial agreement. A key feature of the new bill is the removal of licensing and bond requirements in the entertainment industry based on a finding of the 2010 report that the existing licensing scheme was not effective in regulating representatives' behaviour. The bond requirements were designed to give performers access to funds owed to them by their representatives. According to the review, there was insufficient evidence to suggest that the provision was underwriting any failure of representatives to pay performers what they are owed. The bill retains trust account requirements, which can reduce the risk that a representative might fail or delay an owed payment. The general implication of the 2000 report was that despite the regulations of the licensing scheme in the existing legislation, performers were still at risk and alternate mechanisms should be put in place to protect performers. Amongst the mechanisms introduced in this bill is the introduction of prohibition orders when a representative has breached industry laws repeatedly. Such orders can only be gained by the Supreme Court on the application of the Secretary of the Treasury acting in the capacity of industry regulator and can lead to temporary or permanent exclusion from the industry. The bill also increases penalties for non-compliance with regulations, including the possibility of a $10,000 civil fine in line with the maximum civil penalty in the Industrial Relations Act 1996. On top of these protections, the bill requires representatives to pay their performers within a strict 14 days of its receipt to the representative. Under the previous legislation, the distinction between agent and manager created confusion, as the provisions of protection for performers' pay shall apply equally to both kinds of representatives. That is why the bill replaces the two separate definitions with one definition of performer representative. Performer representative will refer to someone who undertakes a range of professional duties on behalf of the performer, including, but not limited to, seeking or finding work opportunities for the performer and making arrangement for publicity attendances and related publicity responsibilities of the performer. The new 3-day cooling off provision will benefit performers by giving them the ability to seek legal or other advice on the managerial agreement and terminate it if they wish to do so within that period. To provide protection for the representative or representatives, performers will still be liable to pay for any expenses for services conducting during the 3-day cooling off period. The bill also introduces a code of conduct for representatives for the purposes of discouraging poor service and ensuring an understanding of what constitutes good practice in their role. The Code of Conduct includes requirements for a duty of care, due diligence and honesty on behalf of representatives, including that they do not act on behalf of a client unless full disclosure is made of any conflicts of interest. With regards to child performers, the bill requires performer representatives to provide a child with information prescribed by regulations relating to the employment conditions of minors under the Children and Young Persons Care and Protection Act 1998. In terms of child protection measures, the safeguards contained in the Child Protection Offenders Prohibition Orders Act of 2004 will apply to performer representatives who work with children. The New South Wales Government is committed to ensuring a fair work regulations are present in all industries in New South Wales, including the entertainment industry. This bill replaces the old legislation to provide a contemporary framework of practice for the understanding of performers, venues and the representatives. I note that this bill has been developed in consultation with the appropriate stakeholders right across the industry following the 2010 report necessitating the changes. And my electorate of Coogee has some of the most famous entertainment venues. Selena's at the Coogee Bay Hotel, and I'm sure everybody here has been to Selena's at least once in their life, and so it has particular importance to the live bands. Some of them who made their first appearances at the Coogee Bay Hotel and went on to be world famous, and so this is ensuring that the entertainment industry and those who participated in it are protected with necessary legislation and regulation is very important, and therefore I commend the bill to the House.